Hello and assalamu alaikum. Welcome back to our channel. It's been a short while since we did our last video, but we're back with some further information for you. As ever, just a reminder that these videos do not constitute any legal advice. If you need specific advice in relation to your case, then please contact one of our team who will be very happy to help you. What I want to do is firstly to explain the requirements that former spouses of EU nationals needed to satisfy under the old EEA regulations first, before I come on to the points that I particularly want to bring to your attention. Under the old EEA regulations, spouses of EU nationals could get permanent rights of residence if they'd been married for 5 years and the EU national had been working throughout that period of 5 years. There were some exceptions where you could still get permanent rights of residence even though there wasn't the continuous 5-year residence. But in the event of breakdown of the relationship resulting in divorce, you could still get what was known and is known as retained rights of residence in the UK. So what were the requirements that you needed to satisfy in order to gain a retained right of residence in the UK post breakdown and divorce? And the requirements were that 1, you had been married for at least 3 years prior to the marriage being dissolved. Secondly, that you had lived in the UK for a period of at least 1 year. And thirdly, that the EU spouse was in the UK, and fourthly, that they were working here in exercise of their treaty rights at the time that the divorce took place. There are many former spouses of EU nationals who we still come across and who have been refused under the previous EEA regulations on the basis that either their partner had not been working at the time of the divorce, or the partner had left the UK at the time when the divorce had happened, or had left subsequently, and therefore they were not able to provide any of the other supporting documentation from that partner. Now, what is different under the EU settlement scheme? Critically, under the EU settlement scheme, the 2 last requirements that I referred to, firstly, that the partner had to be in the UK at the time of the divorce, and secondly, that the partner was exercising treaty rights, and they almost go hand in hand. You do not need to satisfy those requirements. And so if there are people out there who've previously been refused under the EEA regulations and still find themselves in a state of limbo, you can benefit from this particular provision under the EU settlement scheme. It's not widely known about, and we're still getting many clients coming through who have who were refused under the old provisions but are now able to get permanent rights of residence, indefinite leave to remain, because the only requirements you now need to satisfy are that you were married for at least 3 years, and that your partner lived in the UK for at least 1 year. And as long as you can meet those requirements, you will be eligible for either further leave if you've not been in the UK for a total of 5 years, or indefinite leave to remain in the UK if you have been here for 5 years. In terms of the evidence that you would need to provide, obviously your passport, a copy of your ex-partner's passport, your marriage certificate, evidence of dissolution of your marriage, evidence of your residence in the UK, and evidence that your ex-partner was resident in the UK for a period of at least 1 year. If you require help and assistance with this type of application or any other immigration application, then please contact one of our experts who will be very happy to help you. If you found this video helpful, then please like, share and subscribe, and if there are particular issues in respect of which you would like us to do any future videos, then please let us have your feedback.